let's talk about courts and how courts are changing. Pretty much every society that you can think of, regardless of the legal system that it has adopted, has a court or an equivalent in some way. Courts sit at the heart of all democratic society, and they undertake a remarkable variety of work when you think about what they actually do. Clearly, they're very important in the whole process of enforcing the law. The idea of separation of powers is at the heart of how the justice system works in most common law, well, in all common law countries, and most democratic societies as well. This idea that there is a law that's made by lawmakers, that is investigated and policed by an arm of society that's separate from government and separate from the court. And then the decisions are made in relation to anything to do with justice by this independent body of lawyers, effectively. Judges are lawyers. So courts do all sorts of things. They handle quarrels between people, the citizens of a country. They can deal with disagreements between family members, conflicts between individuals and the state itself, and disputes that businesses have with each other. Clearly, the courts determine the guilt or the innocence of people who are accused of crimes. They settle sensitive questions of national security. They resolve disputes, they adjudicate disputes, and they work out what the law is when it isn't clear. They bring clarity when there's uncertainty. They develop the law, to some extent at least, as changing circumstances require them to do that. And ultimately, they set precedents that influence later cases. Notice how I've talked about the court doing that. The courts actually act through judges, human beings. But do they need to be human beings? That's really what we're going to talk about as we explore this topic. Can we imagine a world where we don't have people at the helm in our court system? And what would that look like? What would that mean both for the administration of justice and for the way that our society would work, as well as what would it mean for your future? If it does happen in any kind of cohesive sense, I doubt it's going to happen during my career, but it could happen during yours. And thinking about that, I think, is a really worthwhile activity because it will bring us back to think about actually what the law is today and what that looks like. So in thinking about these massive changes, it's probably worth stopping for a second and thinking about the ways in which technology impacts the work of courts today. Susskind has basically looked at this, and in the Future Lawyers reading that you have, he breaks this concept of the way that courts interact with technology into two key areas. So process improvements in particular, so automation type improvements, and then the kind of radical changes that this topic is about, the transformational changes. So technology can, without any doubt, technology has been instrumental in a number of different process improvements that we've seen over the 300, 400 odd years that we've had courts in the common law systems in the ways that we understand them. Many of those changes, those process improvements, have happened very slowly, almost without anybody really noticing them to a certain extent. Popular culture, when we think about courts and when we think about judges, we get this kind of old fuddy-duddy kind of idea. We don't have any real expectation that there is a significant amount of technology literacy or technology use amongst judges. But actually, what the research actually shows is that it's more that courts are underfunded than that the people who work in courts are reluctant to use technology. And because by their very nature, courts are really reactive to society around them. So it's very rare for them to be leading in the push to include or introduce new technologies into the ways that they do things. But again, harping back to considerations that we've had earlier in the semester, there is absolutely no doubt that the courts have looked to the profession to use technology when it can increase efficiency and access to justice. That's why we have civil procedure rules that require the use of technology when it would be more efficient to use them, something that we talked about some weeks ago. Not in this lecture so much, but in this topic, in this part of in this week, not necessarily this particular video or podcast, but this week we really will want to focus on the different roles on top of automation that a court can embrace. It's quite clear that there are technologies around that can displace and revolutionise the conventional ways that people in courts work and ultimately bring about radical change, doing new things in different ways rather than old things in new ways. So this is what Susskind refers to as transformational change. And I think this is the core of the Legg and Bell reading that you have, which again, as Legg and Bell do, they're focused on artificial intelligence in particular, but I think for a range of reasons, and partly the lag in uptake and the lack of funding in the courts, the chapter that you've been asked to read this week does focus on some of the other types of technologies that are kind of creeping into the ways that the courts work as well. The third reading that you have this week is a series of case studies. I'll come to them a little bit later. Again, they come from Susskind and in actually his latest work, it's a 2019 publication, coming out of work that he did with the Lord Chief Justice in the United Kingdom, looking at online dispute resolution in particular. Now, if I had my way, I'd make you read the whole book, to be perfectly frank, but I think that tomorrow's Lawyers reading that you have summarises his key thinking in those areas, and the chapter that we've given you in the second reading gives you some really good case studies that will help you think about a range of technical issues, change issues, and also some ethical issues that arise both at a rules-based level but also at a morality-based level, because the transformation piece is so uncertain and so hard. So in order to really understand what the issues are when it comes to online courts, it would really be helpful to have a basic understanding of the technological trends and advancements that have allowed the courts to get to where they are, and that will give us some insight into where they might be going. So Susskind identifies 4 key frameworks. Now, the first one is essentially Moore's Law, the statement that technology is advancing exponentially. So you might not have heard of Moore's Law. I share a birthday with Moore's Law, basically. In 1965, Moore, who was one of the founders of Intel from memory, basically made a statement that every 2 years, the size of a transistor chip would diminish and would get smaller, and the cost of producing that transistor would get bigger. So what you say, you don't use a transistor, you listen to Spotify on Wi-Fi. That was my attempt at a joke. So basically, as you know, the chips are the thing that gives a computer power. So in layman's terms, what Moore was effectively saying is the power of your computer is going to double and the cost of producing it is going to halve every 2 years. Now, clearly there's a point where that has to stop happening, and it possibly has in recent years, but the law held pretty much true for the first 50, even 54, 55 years after it was, the statement was made. I'm not entirely sure that he was trying to plan a law, to be perfectly frank, but we refer to it as Moore's Law, like a formula as such. And over the years of my life, it has absolutely been true that computing power has grown absolutely exponentially. And think about this. You can fact check me if you like. Chances are I won't get everything correct here because I'm going to pull some of these out of my just general memory. But my understanding is that almost half of all of the data that is stored electronically in the world has been created in the last 3 years. So when you think about the library and how much data it contains, whether that's in books or on pieces of paper, the advent of social media, the advent of cloud computing has actually exponentially increased the amount of data that we can store. Changes to the speed and the way the computer chips work mean that huge amounts of data can now be analysed and processed in very short spaces of time. Much of the work that we did in the early half of this semester was around talking about the difficulties that arise because we don't know how an artificial intelligence solves a problem. We call that the black box problem. And it's just computer processing. So if there is some assumption or issue that sits along the way that's kind of thrown our AI, we might not know what that is. Now, of course, actually that can happen with people too. It happens to us all the time. So the absolute growth in computer power and also the ubiquitous nature of the way that we are connected has completely changed the way every business does things, not just the courts. I would suggest that there's been a kind of pandemic overlay in relation to that too. I mean, we can all joke about the lawyer who wasn't really a cat, but the lockdowns and the pandemic itself necessitated significant changes to the ways that many of us worked, even outside of the legal system. Things that were happening pretty much on the edges or just happening socially, like video meetings, for example, have now just become ubiquitous. Like you can go to a funeral online now, which was just something that was really not contemplated in 2019 or before. So there's been this ubiquitous and incredible change, not just at the power level, but at the social level. The second thing that Susskind points out is that we are seeing machines steadily taking on growing numbers of capabilities that for a very long time we thought were uniquely human capabilities. We are seeing growth in technology that allows for emotional and human responses. We are seeing robots being used in a whole lot of caring settings to provide company and connection. This is something that we really probably didn't expect even 5 and definitely 10 years ago. And so it does call into the question whether or not we can get the judges with a human touch. If we can get judges who look and sound and seem unemotional like robots, can we actually get robots and give them emotional touches so they can behave like judges? It's a really interesting question. The third major trend in technology is that our systems are becoming increasingly pervasive. Now, I've talked about that already a little bit in that sense of connectedness, but our expectations in relation to technology change all the time. And we're finding that, we call you at the other end of this video the digital natives. but actually, in many ways, you are the generation, and I'm speaking very generally here because I know that we have participants in this course at all ages and stages, but the straight out of high school group, the kind of traditional LLB students, you've grown up with technology and connectedness, this pervasive access your entire lives, and you're good at using the systems that are made available to you, but probably less good. I'm sounding like Zoolander when I use that language, but less capable than ever of starting from scratch to create new systems and to write the code to do so. There's so much code, and that's a good thing, by the way. You don't need to be able to code in order to be a lawyer or an accountant or a technologist or really any job other than a coder these days. One of the advancement in technology is the no-code solutions that allow lay people to harness technologies in ways that they haven't before. And I think that is super interesting. And the fourth trend that Suskind has raised with us is that human beings are increasingly connected. And again, this has been part of the conversation the whole way. So there are more than 4 billion human beings online at the moment. New behaviours and new activities are blossoming all the time. That brings with it new possibilities, but also new risks that we hadn't necessarily thought through before. People communicate with each other differently and share information differently. And it's these kind of trends that have allowed online courts both to prosper and to become more prevalent in our world. It's also opening new possibilities for us to rethink what a court is for and how to get the best value out of it. Technology enhanced courtrooms have seen particular technologies really used significantly. Now, some of these are really ordinary technologies, to be perfectly frank. They're not sort of things we get excited about anymore, but they've really transformed the ways that courts work, especially since the early 1990s. So, and Susskind talks about all of these in the Tomorrow's Lawyers reading that you have. The first is computer-assisted transcription, so CAT. This is pretty much how I send every voicemail, every text that I send. I am using essentially the open source version of voice to text. Computer-assisted transcription is really just a fancy word for voice to text at the end of the day. It enables words that are spoken in a courtroom to be captured and then converted into text that appears almost instantaneously on the screens of judges and other participants. This has really, really interesting ramifications. Now, at risk of telling you way too much about my own life, but as I've got older, I have found that my hearing is impaired. And the interesting thing about losing your hearing, it's not what I would have expected if I'd ever thought about it as a young person. I imagine if I had thought about it as a young person, I would have just assumed that everything gets softer. That's actually not what happens. In fact, in some ways, things feel louder than they ever have before. It's just harder to make sense of them, particularly when people are talking fast or there are lots of different accents or there are muffled backgrounds. I find myself watching television with same language subtitles all the time, and it saves my marriage, to be perfectly frank, and partly because my husband's hearing is worse than mine and we keep having to stop and explain what's going on. We really are like the old couple that you don't want to have anything to do with. But anyway, that's a story for another day. When we think about what's happening in courtrooms, how so many people, other than the judges and the people who work in a courtroom, even the lawyers are not in the courtrooms every day, not most of them anyway, but certainly the people whose matters are being tried in courtroom, the people on the jury, the people who are appearing as witnesses, a person who has been accused, a person who's having a dispute with their neighbour. Many of the people who are in the courtroom every day are not there all the time. It's a strange and unusual environment for them. People are using language that they're not used to and they're not comfortable with, and things can happen very, very quickly. Having voice-to-text transcription as the subtitles to what's going on can make a phenomenal difference to somebody's understanding of what's going on, particularly when those titles could be automatically translated into their first language. Now, we all know that Google Translate is not awesome. I do a lot of work in Vietnam, and the standard translating software, it comes up with some pretty funny things from time to time. And true translation requires a cultural sensitivity and overload. But I don't know that it is impossible that we will ever get there. The good and the access to justice implications of having simultaneous translation with humans has been well and truly proven. Imagine being able to do it with technology. A second piece of technology that's been used a lot and has really been transformational, and I think will continue to transform the courts, is document display systems. So systems that can ensure that everyone in a hearing is literally on the same page. Instead of waiting for all parties and judges to flick through the papers and find the same thing, to find things manually, the court's attention can be directed to particular pages by asking all the participants to look at their screens, instantly displaying relevant documents. One of my personal bugbears about AGLC 4 is that like many of the, like its predecessors, the Australian Guides to Legal Citation, the original version 2 and 3, technically the rule says don't include a hyperlink. Drives me absolutely crazy. I want a hyperlink, because when I think about it, why are you as students giving me a reference to a case or to a reading or to an article? It's to support your argument, or because you want to show me that you've read something that is relevant and that is useful here. The easiest and quickest way for me to check it, especially because I'm marking your papers online, is to just hit on a hyperlink and have a look, right? When you think about it, well, what are citations for? In the real world, sure, I'm checking whether or not it's actually relevant, perhaps, but the reason that you're doing that is to bolster your argument or to provide access to more information. You don't need to repeat verbatim information that could be bolstered otherwise. One of my favorite research products or available to you as students is Jade. If you haven't checked it out, jade.io, there's some guides to it in the library. But similarly with some Timebase and others, one of the reasons that I like Jade initially is that when I look at a case in Jade, it tells me which paragraphs have been cited most often. Now that's kind of cheat's way of working out very quickly what's the most relevant and most interesting part of that case. If other judges have cited a particular paragraph over and over again, then chances are that's where I'm going to find the nugget of wisdom that I need for a particular scenario. Being able to jump straight to that is important. Now, one of the things that I love about the court's adoption of these more technical display systems that allow to keep everybody stay on the same page is I can see that in the real world, we will see the profession pick up those efficiencies in AGLC and otherwise. But again, access to information and being able to find information online has been absolutely transformative to the practice, but also access to justice generally. And I think it's something that's well and truly worth thinking about. The third technology that Susskind talks about is electronic presentation of evidence. essentially reflecting the old adage that a picture is worth 1,000 words. Now, you will have seen this on any kind of courtroom drama, particularly from the US, where we have video evidence being displayed, the use of infographics, the use of being able to highlight in and demonstrate information in graphical ways. I think this is really, really important. I've actually added another one, so Susskind talks about the first 1, 2, and then 3 here. I've added visual link-ups in here because I really think it's important to actually acknowledge, particularly in a country as big as Australia, how important it is to be able to bring people into a courtroom remotely. And Australia was actually a relatively early adopter of the use of visual link-ups, even though we've been a late adopter of cameras in the courtrooms generally. I think it is worth thinking about ways that, particularly for vulnerable witnesses and vulnerable victims in particular types of cases, the availability of courtroom link-ups. So, for example, taking evidence from children via a link where they can be in a safe space reduces the potential trauma of a particular court hearing. So I think that is one worth talking about. So another thing that I want you to take away from the Tomorrow's Lawyers reading is Susskind points out that, and I think I said this earlier, our pop culture view of judges is that they're old-fashioned and otherworldly. But it is actually important to know that many of them are really committed users of technology, and they're really ready to embrace all kinds of systems that offer practical benefits to their everyday work. Since the 1980s, Susskind has actually been arguing that it's neither technically possible or desirable in principle for technology to take over the work of judges. Now, I guess time will tell whether he's right in relation to that, but that's really one of the key things we're thinking about this week. He does, however, say that there is a lot of work that judges do that is administrative in nature or which could be standardized, which could be done in an automated way or potentially by artificial intelligence. Like all sorts of other lawyers, judges are involved in project management, workflows, automatic court filings. Anything where a system can take data in once and then reproduce that in necessary places, reducing even just somebody's need to look something up and copy out a number or type something, reduces the risk that things will get lost, reduces the amount of time that it takes, and increases the efficiency of delivery. It's absolutely clear that the initial legal research that all of us do is significantly different now than it was 20 years ago, definitely 40 years ago, and absolutely astronomically different from what it was 50 years ago. And so it is worth actually reading through in the detail of what Susskind says about that. And again, even though it's not a required reading by any stretch of the imagination, for those of you who are interested in this, a flick through the more recent Online Courts book from Richard Susskind will really help you with that. Now I'm doing it Susskind, potato, who knows? Okay, so as I said a number of times, one of the questions that we really need to embrace, I don't know that we can answer it, but we need to embrace the question is whether or not, well, what is a court? Is it a place? Is it a service? A little bit from column A, a little bit from column B. This is a question that Susskind has been asked in both of the readings that you have from him. And so we can break it down and think about it as kind of 3 different categories. So there's the physical courts, so traditional courts. Now, the physical spaces are now enhanced by technology. If you go into a court, you are going to first thing you're going to be faced with is technology, because there's going to be a security screening, right? There's going to be technology that's going to make sure that you're not taking anything in that you shouldn't have to take in. The courts themselves, initially the buildings are a kind of technology. Courts were designed so, in our common law system anyway, so that the law is available to the public. For the most part, hearings are public. The courtrooms are set up in such a way to allow people to witness justice being done. Court processes nowadays, well, at least in some courts, are still pretty old-fashioned. Like I've just said that a courthouse in a way is a kind of form of technology, and the way that they're set up is designed to do certain things. But those designs have been around, since the 19th century, effectively. If you've never been there, it is well and truly worth your while to go down to the Supreme Court at some stage. Try and get in to have a look at the library. Just see the way that beautiful room has been set up, basically to make the law available and accessible to the people who work in the courts. There's actually a separation of the beautiful library in the centre from the courthouses around the outside. Again, a kind of homage to that separation of those who adjudicate the law and the law as something that is made by government or otherwise. The technology, having said that, these buildings are often very old-fashioned in their own way. They really come from the time that they were built. There definitely has been infiltration of technologies into physical courts. And certain processes, as we've seen throughout the semester, have become more and more streamlined and provided online. Most filings are done online now. There is a requirement to produce electronic documents rather than to provide physical documents. And a lot of these technologies have been used to a greater or lesser extent in physical courts since the early 1990s. So, and again, the technologies we talked about a minute ago, computer-assisted transcription, document display systems, and electronic presentation of evidence, so EPE. So that's a physical court, a place that you go to have your dispute heard or to have your day in court. I mean, we even talk about it in that way in general sense. The next kind of idea is that we have seen more recently the rise of the virtual court. The virtual court really asks the question, a decision to have a virtual court requires us to ask the question whether a judge needs to be in the same room as the people whose matter is being heard. Do parties and their advisors need to congregate together? Does the accuser need to look the accused in the eye? It's really interesting, as I was saying before, virtual courts have really been taken up first where there have been benefits in protecting vulnerable witnesses. So while physical courts have undergone technological improvements, virtual hearings and online courts are more aligned to what Susskind calls the transformative impact. So transformation as opposed to process. The first time that we saw virtual hearings was back in the 1980s, and really it's countries like Australia where major travel is otherwise needed for minor court appearances that attendance in court by video link became a respectable option quite early on. And definitely during the pandemic, we've seen significant inroads into more virtual court use. So there are quite different uses of video video technologies for virtual courts. So in physical hearings where some of the participants are linked by video, that can be a virtual hearing. But also we can see where no physical event into which some people are connected happens by video. Instead, participants are using video, including the judges, court clerks, lawyers, witnesses, etc., all of them are using videos maybe asynchronously. So when we move from the physical court to a true online court, we see the use of these technologies happening in different ways, and we see the workflows changing in different ways. Now, the third way that we're really moving to is we're seeing this idea of the online court emerge. And it's really worth noticing right from the very beginning that there's a difference between the concepts of online judging and online courts. Online judging, in Susskind's opinion anyway, involves the determination of cases by judges, but the parties don't gather together in a bricks and mortar courtroom. So we're using this virtual court concept. The judges are still looking. They might not even have hearings. They might be but they're looking at the documents. Human people are making the decision. An online court is a different idea altogether. And the idea behind it is that we're going to remove human judgment completely and provide greater access to justice through a transformative process that uses technology. And we're going to talk a lot more about that in the next session as we actually examine what a court is for and what the differences are in a little bit more detail between these physical, virtual, and online courts. I'll see you there.